Larry, 11 years is a long time.
Yes,
long
11
time.
years have passed.
They're over now, and tell us this case after 11 years. What is the significance of the Concord decision and verdict?
The significance is that the Concord finally put to rest the so-called conflict that had arisen in both a decision in the Supreme Court of Appeal in a case called the True Motives case, and the current and a case called the Walele case, which dealt with the very same section, but the reasoning was slightly different. So that has been put to rest insofar as the law is concerned. But insofar as this particular case is concerned, the High Court had put it to rest originally. Judge Seethal in the Durban High Court had made the decision that the Turnbull Jackson's case was a case that he went against, and he found in favor of both Pearl Star and the municipality in the manner in which they had dealt with his plans in the plan approval stage. So Judge Seethal had dealt with that. It was finalized then. It then went to the other levels where they took it, they applied for leave to appeal against Judge Seethal's judgment for various reasons, and I don't want to bore you with those reasons. And then the Judge Seethal refused the leave to appeal. So they then, the Turnbull Jacksons decided to take it on to the Supreme Court of Appeal. They petitioned, and the Supreme Court of Appeal also came to that conclusion that there was nothing wrong, in essence, with Judge Seethal's judgment. The matter then went to the Constitutional Court, and it went to the Constitutional Court based on constitutional principles, because, as I indicated in the beginning of this interview, that it was based on the difference between how the Constitutional Court felt in the Walele case and how the Supreme Court of Appeal felt in the True Motives case. And in order for them to, in order for the applicant to try and get the Constitutional Court to reason this case in their favor, they tried to find blame interesting with the decision maker, and you know the decision maker was Dr. van der Walt. So they created this blame by saying that Dr. van der Walt, who was the plan approver, had some bias against them, and in their reasoning they put up a whole number of reasons, and the court found that all those reasons were unsubstantiated and rejected them outright. The Constitutional Court even went one step further, and they censored applicants who, and in my own terms, who wanted to get their own way by trying to create a fiction that officials are biased. Now, what the Concord says is, if there is really corruption and factors of that nature, yes, that's serious. But when applicants use the courts to pretend and to make false allegations of corruption, etc., because they're not happy with the plan approver, that, the judges said, needs strong censure.
Okay, Larry, the legal people who have listened to you now will understand exactly what you say, but let's think of the people who are watching this now. What is the simple message that comes out? You know, the property in Ramsgate and the blocking of the view, etc., etc.
The simple message is, one must not take it for granted that if someone builds in front of you, that you have the right to a view and you can object to it. Yes, you have the right to object to it. The officials have certain standards and certain things that they have to do to check whether your right is enforceable. Because like you have a right to object to a view, the proposed owner that's going to be building this construction, he also has rights. And so the municipality plays a balancing role in determining whether your right will be obstructed or not. The simple message is this: do not believe that because there is a section in the Building Regulation and Standards Act which says that there could be the possibility of a derogation of value, that you have the right to object to any plan, which you can, but the municipality has a particular method of dealing with these objections.
Last question. Is it not an indictment to our system, our legal system, that it took 11 years to get to this point?
I'm not sure whether it's an indictment on our legal system at all. I don't think it is. You see, if applicants or respondents, or litigants want to use the courts to frustrate any kind of point, they will do so. You take Oscar Pistorius. He's now been convicted for culpable homicide. You've heard the rumor that the state may want to appeal it on a point of law. So now we go from having this lengthy trial that's been with the public for so long. Everyone thinks the judge will now finally make a decision, and yet we know now there's so much uncertainty because the state has the right to go on appeal on a point of law only. And if Oscar's unhappy with it, he can go on appeal in any event. If they go to Bloemfontein and if they are unhappy in Bloemfontein, that's where it ends with Oscar. With this particular matter, unfortunately, it went one level further. It went to the Constitutional Court. But just remember, in this particular case, that the reason why it took so long is plans were approved. It was then found to be set aside by tribunals set up by the Municipal Systems Act. Pearl Star, the respondent, brought a new set of plans. That was then approved, and that took time, and then that was set aside. So unlike you take your criminal case, which shouldn't be too long, but it still takes time, this took a lengthy period of time. So I don't think it's an indictment on our system. I think if people want to use the system to frustrate any point, they can do so.
Congratulations after 11 years
Thank you.
in winning this case.
Thank you.